And let's start off our class here with what I just heard about this morning. I think it was Oxford University, the law school. They are starting to give trigger warnings this is for people training to be lawyers. Anytime they come across some controversial issues like murder or rape or something, they've got to warn the students, and if they feel uncomfortable, they can skip that class. Yes. On the face, it was just really stupid, but these are people training to be lawyers. They just can pretend that there's never murders. Oh, no. Like, I want to be a mathematician, but that multiplication stuff, I can't handle that. Anyway. So that's my trigger warning. We're going to talk about some a murder and a rape and stuff today. Don't you get sick of everybody saying college students nowadays are such wimps? Yeah. Okay, so you guys, those college students are wimps, right? They're coddled so much that anything that makes them uncomfortable they feel is a violation of their rights. And I don't know, Mr. Ramus in PE class would be a violation of your rights probably. So, all right, let's look at these three cases, and then we'll look at the final, right there, both pages. Well, no. Actually, no multiple choice. I'm sorry. All right, let's look at these three cases and see what we think about them, talk about them. Let's leave it there. All right, we already did California Democratic Party versus Jones. Let's do Miranda v. Arizona, 1966. This is a famous one. This is where we get the Miranda rights from. A court decision. It's aggravating. All right, let's go on. Facts of the case. This case represents the consolidation of four cases, in each of which the defendant confessed guilt after being subject to a variety of interrogation techniques without being informed of his Fifth Amendment rights during an interrogation. On March 13, 1963, Ernesto Miranda was arrested in his house and brought to the police station, where he was questioned by police officers in connection with the kidnapping and rape. After 2 hours of interrogation, the police obtained a written confession from Miranda. The written confession was admitted into evidence at trial despite the objection of the defense attorney, and the fact that the police officers admitted that they had not advised Miranda of his rights to have an attorney present during the interrogation. Did I miss a word in there? The jury found Miranda guilty. On appeal, the Supreme Court of Arizona affirmed and held that Miranda's constitutional rights were not violated because he did not specifically request counsel. And then it goes on to the Supreme Court. They issued their ruling there on June 13th, 1966. My sister's birthday. Well, not that year, but that day. That explains a whole lot about our relationship growing up. She was always a pain. All right. She's a sister, right? Well, that's your job. Ask Robert. Does the Fifth Amendment's protection against self-incrimination extend to the police interrogation of a suspect? All right. Let's read the amendment, and then let's see what we think here. No person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, except in cases arising in land or naval forces or the militia, when in actual service in time of war or public danger. That really isn't applicable here. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, really not at issue. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. All right, what do we think? The key phrase there, nor shall be compelled in any criminal case to be a witness against himself.
I think it does extend to him. However, it's his responsibility to know his rights. So, for instance, if the police officers interrogate him, it's not the officer's responsibility to tell him his rights.
Okay, so it does extend to him. He does have this protection.
Right, but if he's not aware of it, that's his fault.
Then he's just an idiot. Should have come to government class. So, okay.
Isn't Like as they're arresting them, they have to say something?
That came out of this case.
Oh.
Yeah. They call them Miranda rights after him.
I don't know, but it says, nor shall be compelled. They didn't compel him or force him. It was his confession, so I don't know how to.
That's the question. So what do you think his constitutional rights were violated?
No.
Okay.
They didn't torture him.
They didn't torture him.
Compelled.
I might have already tipped the scale here about how the court ruled by saying we get the Miranda rights out of this case, but oh well. So you're saying no violation. Anybody else? I think that's very appropriate, and just reading the words, looking at the original intent here of this. He does have that right, but the police aren't responsible to inform him of that. It's his right. He should be aware of it. So, the court ruled otherwise. The court ruled 5-4 in Miranda's favor. Earl Warren, if you've heard that name, was the Chief Justice. They held that the Fifth Amendment's protection against self-incrimination is available in all settings. Therefore, prosecution may not use statements arising from a custodial interrogation of a suspect unless certain procedural safeguards were in place. Basically, the police can't ask you questions or try to get information from you unless they read you those Miranda rights and all that kind of stuff. Questions? Not too complicated, I don't think. I mean, still the court's got it wrong.
I'm just curious, so nowadays, if the police didn't read someone their rights, but he did commit a crime, would he be,
If they didn't,
or...
you're saying that we arrest Jacob for something, since we like to pick on Jacob.
And like they didn't tell him his rights.
Uh-huh.
They know that he was convicted of a crime or whatever. Would they have to let him go, or like what would...
They wouldn't necessarily have to let him go, but he could, if he's found guilty, he can appeal and say his rights were violated, and then the conviction will be overturned. And that really is kind of the underhanded side of this thing. We say just the courts made this ruling. Who are they? But they are the ones making that decision to say his rights are violated. Let's overturn it. But there are other ways to hem the courts in of making those stupid rules. And that's why police are backed in this corner of being so careful about reading their rights and all this kind of stuff, because they don't want to give them any wiggle room to get out on appeal.
So did Miranda walk on
Yeah.
all this? So even though he confessed to multiple things. Yeah. All right, just double check.
That's the other side. Even if the police did something wrong, so did Miranda. I mean, it's not like he was found innocent. He was found having his rights violated. So let's punish the
So
policeman.
now he's what, like living happily?
No, he committed another murder and rape and got convicted for that. So
No.
yeah, it wasn't so good for that woman. But he should have been in jail for the first one. It was just a couple years later, 2 or 3 years later. I don't have that information. Okay, you remember me saying if you figure out what the Constitution says, most times the Supreme Court will go the other direction. It's not that complicated. But here we had some liberal judges who were scrambling to change our whole system. So, all right, let's look at another one from that same era, 1964, Reynolds versus Sims. And they'll do one in our lifespan. All right, in 1961, M.O. Sims, David J. Vaughn, John McConnell. Those are some other cases, but anyway. And other voters from Jefferson County, Alabama, challenged the apportionment of the state legislatures. The Alabama Constitution prescribed that each county was entitled to at least one representative, and there were to be as many senatorial districts as there were senators. Population variance ratios as great as 41-1 existed in the Senate. All right, so what happened? They just split the county up by geographic size, not by population. So you had some counties, well, like I said, some districts had 41 times more people than others. You'd have one district with 1,000 people, the next with 41,000 people, and they both are sending one representative to the Senate. We're talking about the State House, Senate in this case. All right, the question, did Alabama's apportionment scheme, such a they call it a scheme. They want to call it a plan. It sounds like some snake oil salesman. Did Alabama's apportionment scheme violate the 14th Amendment's equal protection clause by mandating at least one representative per county and creating as many senatorial districts as there were senators, regardless of population variances? Okay, so that's the question. There's a couple of pieces in the Constitution here that are significant. Directly addressed here is the 14th Amendment, so let's drop down and read that one, and it's just one section of it. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or process without due process, nor deny to any person within its jurisdiction the equal protection of the laws. So these people were saying that this arrangement for the election violated the 14th Amendment, that particular, the very last part there, the equal protection of the laws, that part of it. That's what their claim was, that it violated that. There's one other place in the Constitution that I think bears on this a little bit, and I put it there right above it. Oh, you know what? That is U.S. senators and representatives. Sorry. That has no bearing. That's members of Congress. I need to fix that. All right, questions, comments, what do we think? Alabama's in the South, so obviously they're doing something stupid. Well, that would be you were born there? Ah, see there? This might be an illustration of the problem. I was born in West Virginia.
Okay. So wait.
But we left the South. I mean, we chose to be in the North. Everyone else just kind of fell on geographic lines. We chose to be in the North. I'm from southern West Virginia, so just barely. So, okay. Alabama or Chicago, that's a tough choice. All right, what do we think here? Sorry, that part from the Constitution, it has no bearing whatsoever. But the 14th Amendment, equal protection. Joy looks like she wants to answer. But yeah.
They could argue that it's unequal because the person who's in a county of 1,000, his vote kind of, I don't know, is somehow worth more, or represented more by the 41,000 or something, I don't know.
And that really is, that's the argument they're trying to make.
Okay.
Yeah.
Maybe you should, I feel like sometimes it could be for the betterment of a certain group instead of the entire state, and also it should probably go into effect after the current.
Whatever the decision was.
Right, it should go into effect after the current people in.
Okay, yeah, I don't know the details of that, but yeah, that would, yes. Joy wants, I can tell.
Well, I don't know, the representation isn't equal, but it's not like they're being deprived of any right. They still have the right of representation. It's just not equal.
Okay.
And they're not being deprived of life, liberty, or
Okay.
property. I mean, I don't know. I mean, they're not being really. I don't know. They still have representation.
Okay.
It's just.
Not equal?
Yeah.
Really, that is the question. Is that variance in the population, does that qualify as not equal protection of the laws?
They still have equal protection.
Okay. Anybody else?
They should just.
If you go one direction, then you'll be against the Supreme Court. The other direction, you can say, well, at least all the smart people in the courts agreed with me. Listen, I thought you were going to say something else. Can anybody think anything about the U.S. House or U.S. Senate and how it's at least ironic if we take this position that this is a violation of the equal protection of the laws. Think about the Senate. How many senators come from California?
Yeah, that's true.
How many come from Delaware or North Dakota?
But that's what the House is for.
Okay.
But you're saying the Senate follows that same line, so what's wrong with that?
Yeah, if we accept that this is a violation, would that not also then, it's hard to say it's a violation of the Constitution because it's in the Constitution, but at least in principle, would be violating this principle. I don't know, to me it's at least ironic. Should we only allow people who haven't discussed anything yet to answer for the next one?
You want to give that a time?
So, all right, the court ruled 8-1 in this one, or the Supreme Court, 8-1 against Alabama. They said this is a violation of the 14th Amendment. And now states are forced to have electoral districts for their state legislatures that are as equal as possible in population, which to me I think is none of the business of the courts or of the national government. I think it's completely a state issue. I really don't think it rises to the level of not being an equal protection of the laws. So, questions, comments? Sarah just put her hand on her head like she's aghast at something. Or are you looking ahead at the next one? Oh, you should have answered on the other one. So like that one, there's you can see a legitimate question. Well, is that? But I really don't think so. I mean, it's not like these people, the people in the county with 41,000 people, or the district with 41,000 people, or we're going to say, well, you know, we're not going to have any fire protection for you guys, but we are for these people. We're not talking about that type of thing. You know, that they had equal protection of the laws in that sense. It just was this legislative, and it was a state issue. The same people that were saying that are getting their rights taken away, they're the ones that at some point made that state constitution. So it's just very much a state issue. This federal government should just completely stay out of it, or at least not be hypocritical and amend the federal constitution. We shouldn't do that. But Kelo versus New London, 2005. New London, Connecticut. What's that? Yeah. Used its eminent domain authority to seize property to sell to private developers. Well, let's just keep reading. The city said developing the land would create jobs and increase tax revenues. Susset Kelo and others whose property was seized sues New London in the state court. The property owners argued the city violated the Fifth Amendment's takings clause, which guaranteed the government will not take private property for public use without just compensation. Specifically, the property owners argued taking private property to sell to private developers was not public use. The Connecticut Supreme Court ruled for New London. And then from there it goes on to the federal Supreme Court, and they ruled in 2005, June the 23rd. They missed my sister's birthday. They should have done that. All right, here's the question. Does the city violate the Fifth Amendment's taking clause if the city takes private property and sells it for private development with the hopes that the development will help the city's bad economy? All right, the takings clause is the very end of the Fifth Amendment. Nor shall private property be taken for public use without just compensation. So the Kelo and the other owners were saying, wait a second, they violated the Fifth Amendment. They took our property, and it was not for public use. All right, that was their argument, and the question is, what do we think?
I think it's certainly a violation.
You think it
Certainly is a violation.
certainly is, okay.
And one thing being, that's not really the role of the government is to create jobs. That's not what they're supposed to be doing.
Okay. You're right. That's very much right. Very refreshing to hear more people say that. Even though you're from Alabama, we'll let you answer.
Did they get compensated for it?
Yes. Yeah, they did get compensated. That wasn't the issue. They were saying you took it for non-private use, non-public use.
Was it like people's houses were bulldozed?
Oh yeah, houses. Private. I don't know if it was all houses, but there were houses involved. They're wanting to turn it into business park. If I remember right, there's a major pharmaceutical company that they were trying to lure in, and they went bankrupt. So the city lost out. Anyway, but yeah, it was private. I don't know if it was all houses, but real private property that they were taking. So eminent domain, that's a legitimate authority that the government has. They can force you to sell their property to you. I mean, imagine trying to build the interstate system, or trying to build a military base, and there's some grandmother who's in the house that they've had for 4 generations in the middle saying, no, I won't sell. And he said, well, you're in the middle of the artillery range. I'm not selling. The government can't force them to sell. We always think of these extreme cases where, well, that's kind of nasty. But there's legitimate reasons where the defense of the whole country really supersedes that person's desire to live in their ancient ancestral little shack. So legitimate purpose. But the question is, does this rise to that level?
Well,
I thought you...
Well, I was going to say something about the interstate before you said it. But
Okay.
then, I ran and I saw this picture, and I think it was National Geographic or something, but they wouldn't give their house up, and so they built the highway around their house.
Oh, that's strange.
Yeah. There's a picture of it. It's like, wow.
There's got to be some story behind that, because typically they wouldn't have the option.
Really?
And the government would say, no, you have to sell. And it's,
But yeah, there was a highway on both sides of that. I should try to find it.
There's probably some backstory to that. So we lost part of our soccer field. It's probably been 15, 20 years ago when they expanded 49. It used to be 2 lanes up there, and they expanded it to 4 lanes. So we lost a strip of land. So it's terrible. Yeah, yeah. My in-laws, I don't know what it was. I think I was in college. It was probably more than that. My in-laws they still own a bunch of it, but it was right by a highway, and they added an entrance to the highway. So all this land, all of a sudden, they're wanting to put exchanges in and ramps and stuff to get off the highway. So they bought a bunch of their property from them. So they were fearful, they're going to cheat us. And no, typically they offer a reasonable price. That usually isn't the thing. There's no advantage to them to try to lowball people, because then they're just going to end up in court for years. And, it's cheaper for them just to pay you a very fair, or even sometimes above market price, just to get it over with. But anyway, they were compensated. Whoever asked. You started us down that path. Or was it Sarah? All right, so we have Davey for sure saying this absolutely, without question, is a violation of the Fifth Amendment. Okay.
I'm going to be the extreme liberal and say, well, it is public use, because those businesses will create jobs for the public and taxes for the public and all these good things.
Okay, and that was the argument of the city. This is, I don't know if they went so much to the jobs, but they're saying this is taxes. We can bring in more revenue for the city. That was the argument of the city.
Feel the burn, 2016.
Feel the burn. We're gonna, no matter what, we might feel the burn. All right, some of the silent folks, what do we think? Perfectly fine for you to say, I'm not capable of conscious thought at this point in the morning. That would be fine if you want to admit that. Sarah?
I think it is a violation.
Okay.
Because it is taking people's private property. I mean, even though they were.
Okay. I mean, that's the government can do that. So it's taking the private property, and where's the violation? Okay, it wasn't for public use. Is that what you're saying? Okay, yeah. Okay. I mean, they can take it. That isn't, the government does have that authority. But the question is this for public use? Is giving it to a developer to develop and turn into a business park or something else where there's going to be a larger tax base? Is that public use?
It's like stealing from the poor and giving to the rich.
Yeah.
Robin Hood up here.
It's a backwards Robin.
So. I feel the tension. So. All right, anything else? Jacob? You've already answered. That's okay. You can go again.
So if the state is not in control of a project, would it not be considered public? Like if the state was going to be in control of the development or whatever, then I guess it could be considered public, right?
Yeah, it's also maybe socialist.
But if they gave it to like individuals and private owners and they did it all and the state really didn't do anything, then it wouldn't be public, right?
Yeah,
Yes.
that's the question.
So it wouldn't be public then because the state really didn't do anything. It's not like the
Okay, no, they weren't.
Somebody else.
They gave it to somebody else. They sold it to somebody else.
So public.
Okay.
What do you think if they needed the money to sell it? So they, well, that doesn't make sense either. Like, buy it for a cheap price and then sell it for a more expensive price.
Yeah.
I guess, I don't know.
If that's legal, I'm going to start taking some of your property and selling it on eBay. I need the money. So, all right, I think Davey's completely right. This is without question a violation of the Fifth Amendment. I mean, this is not for public use. It was just what it sounded. Something that's good for something for the use of the whole country. A police station, a school, a military base. Not give it over to a private developer. I mean, there we have the government literally picking who they think is the more worthy people to own private property. It's unless you're Joel and you want the government to start owning building developments. But we're getting there. Feel the burn. Right? We're getting there. The courts ruled 5-4 in favor of the city. All right. They ruled that this was for public use. John Paul Stevens wrote the opinion. The city's taking of private property to sell for private development qualified as public use.
So you're telling me right now, the state could pretty much show up here and say, we think a business park.
We want to, yeah.
Fairhaven Baptist churches.
Yeah.
And pave it over.
And by that ruling, it would be constitutional.
Okay. America.
Yes. So anyway. I teach this class, so I have some reason to look into these things and follow them a little bit. But you don't have to have a law degree to look at some of these and think, wow, how could they come to that decision? So,